Hey, what is going on, everybody? It is me, attorney Hadi Harp, and today I wanted to mention something that comes up a lot in my practice, and that is people calling in as relatives. Maybe they could be a niece or nephew, maybe they're the grandchildren, maybe they're a friend or other relative to someone who has passed away, and they have been the ones that have been living in a house that was owned by their relative who passed away. Maybe they're paying the bills, maybe they're paying the taxes, and they want to take control over a house that they've have some connection to. And they think that because they are serving in some type of role with regard to the house, that they should have a good claim to take it over. But unfortunately, a lot of times what they don't realize is that when someone passes away, okay, there's really two ways to go about passing along those assets. Number one is if there's a will that was left behind by the person who passed away. If there's a will, then the will give instructions to the rest of the world that say, I want my things to go to this relative, to that relative, to this friend, to this stranger, to this neighbor. It could be anybody that's listed on a will. And typically, unless there's fraud going on, unless there's any challenges or disputes over the validity of the will, then probate court will go ahead and administer that will and get those assets distributed as written in the will. The second way to go about it is if there is no will. If there is no will, that means there's no instructions left behind to the rest of the world. And that means we're going to follow what's called intestate succession laws. Every state is going to have some type of intestate succession law on their books, and that is essentially the default estate plan for someone who passes away without a will. And it's dictated by a formula. So you pass away, you leave no will behind, then there are default intestate succession laws that say, okay, if you had children, if you had a spouse, they're going to get a certain percentage of it. If you passed away without a spouse and without children, then there's someone who's next in line to take over your stuff, and so on and so forth. So when you are a niece or a nephew, or you are a grandchild who has passed away, if there's someone ahead of you in line, like if they had kids and they're still alive, or if they have a spouse that's still alive, they're going to be ahead of you in line, even if you've been living at that house, even if you've been paying the taxes. And so you really need to understand that that is a possibility. And the moral of the story here is, if you think you want to give something, a house, money, a watch, your shoes, whatever it may be, if you think you want to give those things to someone who's not going to be in line, such as a neighbor is not in line under intestate succession laws. A friend is not in line under intestate succession laws. If you think you want to give those things to other people that are not in your direct line, then you're going to have to draft a will. Or if you want to give something to someone who's not at the top of the list, let's say you want to give something to a niece or a nephew. If you have kids, or if you have a spouse, your stuff is going to go to your kids and your spouse. It's not going to go to the niece or a nephew unless you put it in writing, unless you give the world some indication that you wanted this to happen. And how do you do that? You do it through a will. Now, there are some other advanced planning techniques, such as a trust, but that's outside the scope here. This is mainly for people who, think that they may have a claim, or they may have a right to property, but what they don't understand is, unless there's a will with instructions, we're going to be looking at the intestate succession laws of that state, and it's a specific formula where it's literally a percentage of the estate is going to go to your spouse. A percentage of the estate is going to go to your kids. If you don't have a spouse or you don't have kids, that's when we start talking about parents or siblings. And if there's no parents or siblings, maybe then we're talking about nieces and nephews. But there is a formula, and it is going to be a little bit different for everybody. So we're not going to be able to cover all the permutations that may be available for you and your family until you are in that position. And then at that point, we can determine who needs to get the right notice, who needs to have a claim over this, and so on and so forth. And that's all done through the probate process. So that's today's video. There is a pecking order, and the pecking order is based on the formula, and you will refer to that formula if there is no will left behind by the person who has passed away. Thank you. I appreciate you. You can always get on my schedule by visiting estateplanChat.com. Again, estateplanChat.com. I'm attorney Hadi Harp. Thank you, and I will talk to you next time.